Besides the first sale doctrine, there are some other limitations on the exclusive rights that a copyright owner has in his or her work. Just as a recap, the exclusive rights, reproduction, they have the right to reproduce their work, distribute their work, create derivatives or adaptations of their works, to display and to perform their works. Let's talk about some other limitations on these. Teaching. So here's an example. A criminal law teacher wants to show her class the film Minority Report. Showing the film would be a public performance, so potentially there's an infringement. But she owns a DVD copy of the film, so she has first sale rights. But we know that that doesn't allow for performance. That only authorizes her to do what? Distribute and display the work, not perform or copy or adapt the work. So the teacher wants to show the entire thing in her class. There's also an argument regarding fair use. I know we haven't covered that yet, but there's a test that is involved with fair use. Is it for educational purposes? I'm not charging the students. It wouldn't hurt the market. I don't know. Would it hurt the market? Maybe the students won't go and buy a copy. So there might be an issue with that. We'll discuss fair use in a little bit. So how do we get around it? The law allows for it. Section 110A authorizes performance of display of a work by instructors or pupils in the course face-to-face teaching activities of a nonprofit educational institution. So what's the limitation on performance or display? I can't copy it and I can't give it out, or the teacher can't. It only applies to instructors or pupils, meaning the teacher couldn't have a guest lecture come in and show it. If it's shown as part of a fundraiser or a movie series, doesn't qualify, no can do. In a classroom only or similar setting devoted to instruction. So I couldn't take a class to a theater or my house and show it, right? The teacher couldn't. What about distant learning? Online. Similar protection for distant learning with a few extra differences related to providing written materials of the works are protected and only used for educational purposes. But it still applies in that realm. You just can't hand out copies. And there's a couple other restrictions. We don't need to know, not going to go into those. You just need to know that the exception applies to online learning as well. Let's talk about, this one gets a little sticky, nonprofit performances. This is when there's no permission. You don't have permission, but it's a nonprofit performance. The law allows for it. It says there's no infringement if the performance of a non-dramatic, literary, or musical work. Otherwise than a transmission to the public without any purpose of direct or indirect commercial advantage and without payment of any fees or other compensation for the performance to any of the performers, promoters, or organizers if there is no direct or indirect admission charge, so you can't have an admission charge, or the proceeds after deducting the reasonable cost of producing the performance are used exclusively for educational, religious, or charitable purposes and not for private financial gain. So let's break all of this down. So what types of works are we dealing with here? Let's say which types of works we're not dealing with here, right? Dramatic, literary, musical works. So a play or an opera. Can't be a play or an opera. But everything else is fair game. Can't have a commercial advantage. So nobody's making money. Can't be for commercial purposes. You can't be paying people to be involved with it. You can't charge an admission. You can seek a donation, but you can't charge an admission. If all of those things are met, then you don't need permission from the copyright owner and you can perform the work. But the copyright owner does have a right to object and prohibit the use. And here's the odd little clincher in all of this. There's nothing in the statute that says, if you're having a nonprofit performance, that says you have to notify the owner of the use. So how do they find out? Who knows? Publicity, maybe. They hear the word gets out. And if they find out, they can object. They can say, no, you can't use my work, but it must be done in writing and at least 7 days before the event, and give reasons for the objection. And any reason will do. I don't want you to use it. Good enough. So where might we see some of these kinds of objections? What might you think? How about this example? Bruce Springsteen learns that a candidate for political office has been playing his song Born in the USA at his or her rallies. The politician's staff has met all of the elements of the above for the rally, what we just discussed. Nobody's making money. It's not for profit. There's no admission fee. And all the money is going to go to, what, charitable purposes, religious purposes, educational purposes. If there's fundraising going on, it's not for commercial gain. So what happens? Springsteen has considerable different point of views than the candidate. The candidate has a big rally coming up in 3 days. Can he order the candidate to cease and desist? Well, they have to object within 7 days, so it's kind of too late. Anything else? If it's, let's say it's 10 days and he finds out, can he object? Sure, he can send a letter. Done within 7 days before the event, and give a reason. I don't agree with your views. I don't want you using my song. But we got 3 days. Can he order it? It's going to be too late. It's going to be too late for the event. And most of the time this comes up after the fact, after the candidate has used the song and it's out there in the public. It's normally when you hear of artists getting upset about their songs being used, and then they send letters saying, don't ever use it again. I don't support you. Also, though, even if Bruce Springsteen was within the 7 days to object, it really will depend on the venue, because there are some venues, especially auditoriums, that have blanket licensing fees from folks like ASCAP and BMI, those licensing outfits, to which they can use regardless of meeting those conditions. If there's a license and you're in that venue, free to use the song. And there's also been some arguments about fair use. And like I said, it happens all the time. John Mellencamp has gone after folks. Hart has gone after Sarah Palin for using songs. So let's try an example here. See if we can meet this test. To raise money for care of homeless pets, a theater group stages a benefit performance of the musical Cats. The performers all work for scale, which for some is a mere fraction of their normal fee. The organizers, directors, stagehands, and others all work for minimum wage. The admission fee is $20 per person, with the proceeds after the cost of production going to the pet rescue charity. An additional $5,000 comes from selling naming rights to a local pet store whose name is prominently advertised. Permission is not sought from the cat's copyright holder because the group believes that the nonprofit performance is authorized under the Copyright Act section. Is that true based on what the example provides? Well, let's start with it's a play, so it doesn't meet the non-dramatic literary option. So boom, that's going to take it right out. But there's a number of other problems with this. They're paying their performers, right? The performers all work for scale, which is a mere fraction of their normal fee. They're charging an admission, $20. So in this instance, there's a few problems with that, and they would definitely need permission. But that is an example of something that's commonly done. And because it's nonprofit, that's not the only well, we're not making any money. There still could be infringement. So another limitation is compulsory license for non-dramatic musical works. This allows musical works to be recorded and distributed without permission of the copyright owner as long as statutory procedures are followed and statutory royalties are paid. We're not going to spend a lot of time on licensing itself, but you should know that this is out here and it's a cause for a limitation for copyright holders. Once an authorized phonorecord of the works has been distributed in the United States, anyone else may obtain the compulsory license to make and distribute phonorecords of that work. So this is where we get the idea of cover songs. Karaoke uses this. You may remember that case way back under the right of publicity in the Bette Midler case, where Ford got a different voice, someone that sounded like Bette Midler, but they completely licensed the song. This is how they got it, but they had somebody else sing it. But the key here, the key component to this is the actual copyright owner has the authority to choose first who records it first and first distribution. After that, it's fair game and you don't need permission. So, you'll hear a lot of the original artists or hear cover songs, and they don't agree or they don't like it, and the question comes up, well, why'd you authorize it? Well, I didn't, because of this particular license. So what does one have to do to get a license? Basically serve a notice of intention to obtain the license on the copyright owner, and the copyright owner gets the royalties that are set by the statute set forth. So why this license? Basically to keep musical compositions available to the public while assuring the copyright holder still gets their licensing fee. Otherwise, the song will be out there the one time and possibly never heard again. So they allow for the recreation or the re-recording of the musical composition. There are limitations on this, though. You can't duplicate the publicly released recording, so it cannot be exactly the same. Cannot be exactly the same as the publicly released recording. It authorizes a making of a new recording, i.e. a cover song, but you can't change the basic melody or fundamental character of the work. Okay, so you can't radically alter it, okay, i.e. derivative. No other uses. There are absolutely no other uses. So you can't publicly perform it, and you need to get permission if you're going to perform it. So you see some problems with this? All right, so I got this compulsory license. This is great. I'm going to record it. Maybe it's your favorite Bette Midler song. I'm going to record it. Now what? You can't go out and sing it and perform it. You need to get permission from that. So that's a whole nother area of licensing. So you can see there might be some problems. So the real reality is whoever wants to use somebody's song, they kind of skip this compulsory license that's required by statute, that set statutory fees, and they go right to the owner/publisher and get an agreement that encompasses all of the rights. Obviously, they pay more for that, but that's generally the way that should go. And, of course, these are the limitations that I just set forth. Cannot duplicate the publicly released recording. It only authorizes the making of a new recording. However, you can't radically alter it, and you can never publicly perform it without permissions. So libraries and archives is our other section that limits the exclusive rights on our copyright holders. Section 108 authorizes libraries and archives to make and distribute copies of works for various purposes, subject to detailed conditions. A library can make 3 copies of a work in a collection for preservation and security. They can make a copy of a magazine article for a user's private study, scholarship, or research. They may make a copy of an entire work for use if a work is not attainable elsewhere for a fair price. Copies must display the proper copyright notices. Libraries must have copyright warnings displayed everywhere. And a library must be open to the public or researchers in a particular field. So there are some stretches here for libraries and archives, or I should say there's an exception here for them to make copies and in limited amounts of display and distribution. There is another limitation on exclusive rights. If somebody plays, think about, you're going out in public, maybe you go to a park, maybe you go to a beach. If someone plays, they bring their radio. Some folks, bring they used to anyway. Now you got your phones, you can watch TV on. But there used to be these little portable TV things that people would bring. You could set up at the beach, watch TV, play the radio. Is this a public performance? Think about a location, park, beach, sitting on a sidewalk in your lawn chair out front of your house. There's the public. There's people walking by. Is this public performance? No, that is not public performance unless you charge somebody or you use a piece of equipment like a PA system and broadcast a lot, or a speaker system that sends the message a lot wider than you're sitting next to you in your lawn chair with the volume turned all the way up. You might be outside washing your car and you got the radio turned on or blasting. So that's another limitation on the exclusive rights. So those are a few that exist, and that concludes our discussion on the statutory rights that a copyright owner has with regards to its works. So our next topic we're going to switch to is we're going to kind of narrow it down. We'll talk a little bit more about music and sound recordings, and there's going to be a video I'm going to have you guys watch in addition to very small. I don't have a whole lot of lectures because it's just going to be kind of like a little recap, a little something new, but I want you to watch a documentary on music and copyrights.